Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to people all the time about accident cases, and a few of those people that we talk to either are thinking about bankruptcy, are in bankruptcy, or are at the end of a bankruptcy. So I wanted to talk about how personal injury cases interrelate with bankruptcy cases and hopefully steer people in the right direction when it comes to how to handle this issue. So many people don't realize that when it comes to a personal injury case, that case is actually an asset of, or considered an asset of the injured person if and when that person is considering or declaring bankruptcy. So the thing that people don't realize about this asset once they declare it is that it actually becomes then property of the bankruptcy trustee. And the bankruptcy trustee becomes our client in a personal injury case where the person, where our client has declared bankruptcy. So the bankruptcy trustee then, gives us the directive to go out and get as much money as we can, as we typically do on cases. But at the end of the personal injury case, we give that money to the bankruptcy trustee, and then the bankruptcy trustee decides what to do with it. That may include paying creditors, it may include, paying off credit card companies or mortgage holders or whoever, and it may ultimately some of it may trickle down to our client. So that's how cases work when someone's in bankruptcy or thinking about bankruptcy. The question becomes a little bit grayer if a person is in bankruptcy when their injury occurs, but they don't bring the claim until after their bankruptcy is discharged. That happened to us in a very recent case, and it became a big problem in the case because the insurance company on the other side had done their research, had done their court research, and found out that our client was in bankruptcy at the time of her injury. And so they made a big stink about it, and we ended up in bankruptcy court arguing with the trustee and in front of the bankruptcy judge over this issue of who did the case belong to, or who did the claim belong to, and that sort of thing. It was pretty unpleasant for our client. It wasn't fun for us either. The insurance company probably had a good time with it, but at the end of the day, it did work out well for our client. But I think the moral to the story is that in terms of bankruptcy and personal injury cases, it's always best to be upfront and to report, tell everything to everybody in terms of your lawyers. If you have a bankruptcy lawyer, tell them that you've been involved in an accident, tell them that you have a case. If you have a personal injury lawyer, tell them you have a bankruptcy lawyer, tell them you have a bankruptcy case open. Because once everyone knows what's going on, then everyone can work together to try to make the absolute best result for the client. Otherwise, if everyone's not receiving the same information, then the lawyers that are involved in the case can't protect their clients to the best of their ability. So make sure you tell your lawyers everything that's going on in your life, whenever you're involved in a personal injury case. If you have any questions about a Florida personal injury case, how it relates to a bankruptcy, if there is one, then please reach out to us. We love to answer questions. All you have to do is call our office at 407-254-4901. You can text us at 407-644-4444. You can always send me an email with a question. My email address is kcullen@cullen-hemphill.com. Or you can visit our website or our YouTube channel, where we have literally hundreds of posts of information just like this on virtually any topic you can imagine dealing with